Good morning, everyone. My name is Dwayne Schultes. I'm the Managing Director of Vital Transformation, and I'd like to welcome you to this EBE webinar where we will be discussing intellectual property and its value to Europe. We all agree that Europe is doing a great job developing and de-risking new biotech intellectual property. That's been Europe's strength. But we're finding that IP is struggling mightily within Europe to commercialize. So what we're going to try and do in this webinar will be discuss what role IP and incentives play for SMEs to develop innovative medicines and also to create economic benefits. And I'm very pleased today to be joined by Barbara Friesham from the European Biopharmaceutical Enterprises, EBE. Hello, Barbara. Good morning.
Good morning.
We're also joined on the phone by Joep Myers, who's the partner at Life Sciences Partners in Boston. Good morning, Joep. How are you, sir?
Hi, good morning. Doing well, thanks.
Thank you. And also from Belgium, Emile Pot, who's a European patent attorney and founder of Activanics. Good morning, Emile. How are you, sir?
I'm fine. Good morning.
Good to speak to all of you. So we're going to get started with a presentation from Barbara, but first we just want to discuss some of the tools. If you're having audio issues and would like to interact with us, you can change your audio settings. I imagine most of you are on Skype settings right now. So if you need to dial in, if you're having trouble with your audio connection, please switch to the phone. We've provided 20 international phone numbers. We'll also be holding an open Q&A at the end of the session for about a half hour, and we have a question bar, and you can see there that there's a little question bar, and you could submit any question you'd like, and we will endeavor to answer them. So with that now, I will hand over to Barbara, who will make our presentation about IP. Barbara, the floor is yours. Thank you.
Thank you. Well, the title of my presentation basically says it all. Intellectual property is critical to bringing innovative medicines to patients. If you could go to the first slide, please. Thank you. I would like to start off with a few words on what intellectual property actually is and what the different modes of protection are that it grants, and then I would like to move over to the relevance for medicines and the role it actually plays in the innovation ecosystem in Europe. So intellectual property is really a legal means designed to foster creativity and innovation by ensuring that creations of mind, whether they're inventions or artistic works or literary works, can be protected, and that the person who actually invented them can earn recognition or even financial benefit from what they thought up. You have a number of different legal means to do that. Best known are probably patents for inventions of a technical nature mostly, or a process nature, copyrights for names and or songs and literary works, and trademarks, which are usually the big brands. And what this legal instrument tries to do is strike a balance between the interests of the innovators, which is basically earn recognition or maybe even financial gains, and the wider public interest. And the IP system in general simply aims to foster an environment where creativity can flourish. Different levels of protection apply to different types of IP. Most people know that a patent life usually is 20 years, but actually only if you pay the fees. Copyright, for instance, is a lot longer than that. It's usually the lifetime of the author of a song or a book, plus 70 years. And as an illustration, EBE is based in Brussels, and the Atomium today, 59 years after its creation, you can still not use pictures of the Atomium in a commercial brochure without prior authorization. And that will run on until 2075, so quite a long time. Next slide, please. I said it before, and I think it's really important to keep it in mind for medicines. Patents are a contract between the inventor and society. You only get a patent when you actually explain in intimate detail what it is that you invented. And when you basically give away what you did, you get a limited period of time of protection. Well, it's not really a protection, it's the right to exclude others from making or using or selling your patented invention. But you have to give away what you invented, so others have the opportunity to maybe find a better solution to the same problem. And also your right is not automatic, it can be challenged, and you need to fight for it in court. So a lot of hard work goes into having a patent and maintaining it if ever you're a good inventor. Next slide, please. Before I move on to what it means for medicines, I would like to remind you that it takes a long time to bring medicines to market. Anything between 8 and 12 years to get the marketing authorization, and even if you have the marketing authorization, that doesn't necessarily mean that you can already start selling your medicines, especially in Europe, where you need to agree price and reimbursing with other authorities. So typically medicines reach patients only a long time after the patent for the medicine has been granted. Next slide, please. And right, so back to patents for medicines. So for medicines, the same holds true as I mentioned before. You have to you have to publish your invention and allow others to invent around it, but also while your patent is there, others can make exactly this, can learn to make exactly the same thing that you invented, and as soon as the patent expires, you usually have competition and much lower prices for an innovative medicines for many years, and that's actually high value for society because somebody invented something that's valuable to patients. So going back to my slide before, because it takes so long to get medicines developed and approved, the effect of protection for a innovative medicine is usually much less than 20 years. For that reason, in Europe, there is a limited extension to the patent term when a medicine is authorized and when it meets certain conditions. This extension is not very long, but it's a critical tool really to stimulate the development of medicines and simply ensure that the effective period of protection under the patent and the SPC is sufficient to foster investment and research into new innovative medicines. Next slide, please. EBE is an association that not only has large pharma companies as members, but also biopharmaceutical SMEs. And I think the others on the panel can talk to that even more, but for an SME, patents are fundamental to the survival and the success of the company. Usually, small and medium-sized enterprises have innovative ideas, but no money. But that means they have to secure funds. They have to get others to invest into their ideas. And the only way to do that is really to have intellectual property, have your ideas patent protected. Next slide, please. You might think, why should you care about SMEs? And in the next few slides, I would really like to explain how it is what value SMEs bring to the economy in general, to the innovation ecosystem for medicines, and I hope then to leave you with the impression that it's important to ensure that SMEs thrive in Europe. So the Commission a few years back really highlighted out the value of SMEs as drivers of economic growth, innovation and job creation, and 99.8% of European enterprises are really made up by SMEs, and when they counted in 2014 it was over 20 million. These SMEs generated 85% of the new jobs in the private sector outside the financial industry, and they also employed way more than half of the employment in the private sector. In total in 2014 it was close to 90 million jobs in Europe. Next slide please. So, is that SMEs in general or SMEs in biotech and healthcare as well? OECD looked at it to a certain degree, and again, SMEs also play a very important role in biotech, with more than 75% of all biotech companies in the 18 EU member states they surveyed being SMEs or really micro companies of 50 or less employees. And now I really come to its importance in the innovation ecosystem. The EMA analyzed where medicines actually come from, who made the original invention. I focus on large pharma and SMEs only, but clearly also some of the medicines come from academia. So if you look at all new medicines authorized in between 2010 to 2012, almost 30% of all new medicines originate from SMEs. If you then look at orphan indications and rare diseases, that percentage goes up to 61%. And I think that's quite significant. This is really where the medicines originate from, the people who thought them up and started to develop them. And, you know, for orphan drugs, only 11% come from either intermediate size or large companies. And for all medicines, it's 21% for large pharma and 28% for intermediate-sized pharma, respectively. Next slide, please. Sorry about that. It's a duplication of the last one, except the last point on this slide. I'm sorry. Would you mind going back? If you look at the last row of text on this slide, I really would like you to consider the whole thing as an ecosystem, because what I mentioned before is who were the originators of the new medicines, but that doesn't necessarily equate to who actually then brings the medicines to patients, and that's where the role of large and intermediate-sized pharma lies. In the end, almost 60% of all marketing authorizations are held by large pharma companies and 28% by intermediate-sized companies, with only 13% of SMEs being in a position to market their innovations on their own. So I think it's we do well to think of Europe as an innovation ecosystem where SMEs play an important role in having great ideas and doing their initial development, whereas the other larger experienced companies have a very important role in ensuring that the medicines are then brought to the market and to the patient. Next slide, please. My last few slides are basically something that the European Patent Office and the trademark office in Alicante published late last year, and it's just to make people, to highlight that intellectual property is actually good for the European economy. And in this, in their survey, they found that more than 40% of the total economic activity in Europe is generated in intellectual property rights intensive industries. That again, almost 40% of all employment, equating to more than 80 million jobs in Europe, come from business that have a higher than average use of IP rights. Next slide, please. Very good. Not surprisingly, the average wages in IP-intensive industries are higher than in other industries, and also the intellectual property rights intensive industries play a very important role in external trade of the EU, with a very high share of the imports and even higher share of exports, 85 and 93% respectively. So in the period 2011 to 2013, a surplus of close to 100 million euros was generated by the IP-intensive industries. Next slide, please. Again, from the European Patent Office and the Intellectual Property Office, IP-intensive industries are more resilient in the face of economic crisis, as shown over the past years. And, you know, in Europe, IP in relation to medicines is perhaps considered, well, discussed controversially. It's important to remember that intellectual property is really an important economic driver and therefore benefits us all. And I think with that, I have reached the end of my slide.
Thank you very much, Barbara. We appreciate that. So this is really the industry position on what happens with IP in the course of the development of a drug. What we have is we have two experts with us, Joep Myers and Emil Pott, who will come back to us and address how this works both from the individual investor standpoint as well as from the people who are developing the IP. And Emil, you're the latter. You had a successful startup that you spun out. Can you tell us how that worked and how you monetized the IP?
Yeah, so in 2006 I co-founded the company Actogenics, which was developing oral delivery of proteins via engineered food-grade bacteria. And that was a whole new field that we discovered. It was already in the 90s, and we decided that we wanted to have a very good IP position on that, because the IP position was and that appeared to be crucial in collecting the first Series A financing round, where also LSP was one of the co-leads. There in the IP due diligence, that was very clear from the beginning, is that persuaded and convinced the investors to put in 30 million euros in the Series A financing round, which was at that time a very large amount. But basically we dominated the whole field of oral delivery via engineered bacteria. Within the company I was responsible for further building that IP strategy, which was very much aligned with the R&D strategy and focusing on the business opportunities and trying to capture as much as value as possible that was created in the R&D. And finally, that resulted in the the trade sale of the company in 2015 by a US company called Intraxon, which was primarily based on dominant IP position that we had in that whole field, which comprised about 30 patent families, and there was more than 150 granted patents. 150 running patent applications, and that covered over the major markets in at the world, so US, Europe, and Japan.
And so, from your standpoint, did you see yourselves as a technology company, an IP company, or both? I mean, was the IP integral to making this work?
Yeah, it goes hand in hand. So no IP without technology, and no successful technology company without IP. So that really goes hand in hand.
And this, Barbara, this illustrates what you just said as well. It shows that, you know, a small SME gets a bit of seed funding, then it gets pushed off to a larger company to commercialize. I mean, do you see EBE's role as facilitating this in Europe as well as internationally?
I would phrase it like slightly different. I think EBE's role is in making sure you have an environment where people can do what they do best, and that is for SMEs to innovate and find the funding, and then either bring the medicines to market on their own or sell either the product or the company to a bigger pharmaceutical company that might be looking for new innovations for their product portfolio.
Now, you were one of the investors in Emil's company. You were at the early stage in stage A. Can you explain a bit how you manage intellectual property from an investor standpoint, and what primarily you're looking for when you're trying to value IP? What do you think is good value? What do you see as an investable opportunity?
Sure. So, look, I think my perspective here is probably not too different from most investors in the life sciences arena. IP is important for the simple reason that if there were to be no IP protection and a medicine were to be developed and launched and made available to patients, at some point, if there's no protection, everybody can copy it, and it goes against you know, the financial and business model, whereby, you know, it's expensive to develop a medication, as we know, and so at the end of that, you need to be able to recoup your investment. That's in a way, that's simple economics. Now, what that means for investors is that, yes, particularly at an early phase, we need to convince ourselves that the intellectual property position of a company we invest in is strong, meaning that if we talk about an individual medicine, they need to have composition of matter, or at least, you know, based on the correspondence so far, it should be conceivable that they get that. Then there's other ways of protection, use, patents, manufacturing, all these things. But we need to summarize that, we need to feel confident that, let's talk about a medication in development, that can be protected as such. Now, let me try to step out of my comfort zone a little bit here. That's the way investment works, and any investor will tell you this, and this, in my humble opinion, will not go away. There have been cases whereby IP, I believe, is being pushed too far. And that's an important point for me as well. If you look at some of the drugs that have been protected and that have been able to more than recoup investments, there are strategies out there by companies where they kind of try to extend that IP protection beyond what in a way can be reasonably expected from the system to bear. And when we talk about, you know, some pushback that we've seen on the IP side, well, there's something to be said for that, right? I mean, if you have developed a drug which has already been quite successful, at some point that patent protection ends. And you know, it's also not too bad that when that happens, and if it's a small molecule, that indeed other versions become available, because that takes costs out of the overall healthcare system, which, you know, these are not finite budgets, as we know, and which will make room for new innovation to come. So IP is a complex issue. At the early stages of investment, it is important, and many investors will tell you that. But at the end phase, at some point, there's something to be said for more widespread access to drugs that, you know, are coming off patent. And to give you one example, small molecule, you're absolutely right. I mean, here alternatives come in quickly and typically at quite a low price, typically. On the biological side, you see what's happening with the biosimilars, where Europe has actually been much more forthcoming, I would say, than the US. But in my opinion, again, biosimilars are not that much of a threat, because by having biosimilars, you take some pressure off the healthcare costs and the healthcare system, and make room for new innovation to come. And I think any innovative company, and I know, Barbara, in your vast number of companies, there's a lot of highly innovative companies out there. They shouldn't be afraid of that. So let me, I know it's a bit of a broad statement, but I'm trying to give you the perspective not only at those early phases, but also across the life cycle of an investment in IP related thereto.
So that's great. Now, just quickly, what specifically do you like when you're looking for a company and their IP? What are you looking for value? What is it that really drives you to say, okay, I'm going to put $10, $20 million. I'm going to authorize our funds for that. What is it that really clicks that decision for you?
Well, that goes back to how do we make our assessments, right? And there's many aspects to doing an investment in IP. It's a very important one, but obviously, let's say again, let's talk about a medicine that needs to provide financial benefit over and beyond the standard of care and all these things, right? The company has to be well funded, management team has to be good, but as you said, IP is an important element of that. What we're looking for is that, if a company, let's say, develops a drug and brings it all the way to patients, that if and when that happens, with all the hurdles and all the risks associated with it, that drug is then protected, meaning that the company can recoup some of the investments that were made, and will have a period of time, which can be longer or shorter depending on the development process, as Barbara described, during which they have time to recoup their investment. And that can be based on many things. Typically, composition of matter is important to us. But you can also think about, repositioning, and then you need, for example, repositioning of known entities where you would have protection based on the use in a different setting. So it's a broad question you're asking me, Dwayne, but I guess the common denominator is that the IP should allow for the company to have freedom to operate, to be able to have a drug protected for a significant period of time during which you can recoup the investment.
That's great. Unfortunately, Henk Hughes was unable to attend today. He's been unable to appear with us. He does send his apologies for that. We're very sorry for that, but we'll certainly carry on an endeavor without him, and we'll certainly send questions that are forwarded to his attention his way. I'm going to kick things off. Joop alluded to this in his presentation. There are increasing pressures against and a backlash against IP by civil society organizations, particularly in Europe. What would be the impact if we lost IP, and what right now is the current approach to deal with these arguments that people say that IP is causing drugs to be too expensive, IP is not valuable? What would happen if, say, tomorrow IP is gone? Who wants to address that? Barbara, why don't you go first?
Well, you picked the right and the wrong person. I come from a family of patent attorneys, so I'm one of the odd people out, but my parents and my brother all were or are patent attorneys, and so it has a very immediate effect on my family if IP were to go away. I've seen how intellectual property has allowed companies to do what they do well and to grow and really bring service to society. No company will continue to exist if their product is not bringing any benefit to society. And if you talk about medicines, it's usually that we're treating something that somebody has to live with and doesn't necessarily live comfortably with it, and up to life-threatening diseases. So you need to ensure that there is an environment that allows companies to innovate. IP is often put in relation to prices, and as Joop said, I'm quite sure that in the past things have been overdone in terms of, or may have been overdone occasionally in terms of, well, too extensive IP protection. But then I'm actually not the expert on that and would defer to others for that. So I think people have all the right to ask questions of what role does IP have in the medicine's life cycle, but IP does on its own doesn't necessarily drive prices for medicines. And so I think those are separate discussions that need to be taken separately. I only know that if you don't have IP, you don't really have an incentive to innovate. And therefore, for me, it's critical to maintain that.
Emil, from your perspective, I mean, you just successfully sold IP. What would happen if you would? What would have happened to Actogenics if you did not have IP?
Well, I think in the first place that yeah, nobody would have invested in Actogenics. So to develop a medication through the clinics towards the market, it costs a lot of money, perhaps up to 1.5 billion, maybe even more. So this is money that you need to get from somewhere, and yeah, normally you get it from investors. But these investors would only like to do that if they can recoup their investment, and that can only be done if there is some kind of control that you have on who is able to use, sell, exploit the inventions that you're doing, or the medications. So and that mechanism is called patent rights. So basically, and the business, the commercial model that we have in the Western countries is that, yeah, we rely really on these patent rights to secure the investments for developing further the innovative medications. So besides that role that I had within Actogenics, I'm also an expert for the WIPO, the World Intellectual Property Organization, and many times I'm invited on mission to countries like Zimbabwe, Kyrgyzstan, Turkmenistan, etc. And also there they often ask me the question and say, okay, we don't want any patents because of patents, because of IP, we can't have affordable medications here in our country. And then I mostly have to say to them, well, listen, from the top 10 drugs that I have mentioned in my presentation, I've done some investigation, and guess what? There is no patent on any of these drugs in your country. So, you know, please go ahead. You can do it yourself for free. And then there's a silence, because that's not the problem, you see. So IP is not really the problem for these countries where there are no medication. Actually, I would say is that because the lack of IP, there is nothing.
Yeah, so you're saying it increases the risk for people to enter those markets, and there's no desire to actually develop, and that way it gets crushed, which is understandable.
Yeah, exactly. And if you look at how Egypt is doing that, so also there's hardly any IP, but Egypt is then seeking contact with Gilead to see if they can have Sovaldi being distributed there, and having some kind of a collaboration to make sure is that in these kind of countries there are affordable medications like Sovaldi.
Yes. We've got a very good question here from Boris Azace from MSD. Hello, Boris. I hope you're well. Thank you for listening. Boris says he has a comment first. The question is not whether IP is necessary or not. The question is how much IP, how long should the protection last? Unfortunately, Boris, I have been at conferences, many conferences in Brussels, where I have heard people say that we should get rid of IP. So it is becoming, I agree with you, it's not credible, but it is unfortunately becoming an issue. But he does bring up a good point. How much IP, how long? And you brought up this point. How long is a piece of string, I think, in many ways, this question is, but what is the correct length of IP from your perspective as someone who's both buying and selling?
Yeah. You know, that you realize that that's a very difficult question to ask. I think that I'll come back to what I said before. And by the way, I agree fully with what Emil just said.
Yes.
I think that where the industry might not be doing itself a favor or anyone a favor is at that tail end, where there are huge legal battles to drag out the patent life of a drug that conceivably should be generic, and that's one thing that we see. The other thing that we see is people taking advantage of a system whereby a drug has become generic, but by fact that it might be, for example, manufactured at a single site, you secure access to that site and you raise prices. These are some of the bad actors in the industry, and this is another thing that I've noticed in the discussion. We should kind of set apart people who focus on innovation and need the patent protection for that, and compare that to some of those who don't focus on any innovation but abuse the system on the IP side. So again, that's a broad answer, Dwayne, but I do feel that I come back to what I said before, that this is something where people should not be afraid. If you are an innovative drug maker, you're going to need the IP to protect yourself. I understand that. I think many people understand that. But at some point there comes a time where the industry again goes overboard, and that's my point about, sometimes it's pretty, these questions are not unreasonable, right, for people to and take, for example, I come back to biosimilars as well. I've heard quite a few senior executives say, who themselves run large entities, small and large entities, they're not worried about biosimilars, right? And they sometimes don't understand why it takes so long, for example, in the US to get some of these things approved. And the reason why they're not worried is, again, because we realize that budgets are finite, and it forces you to be focused on innovation. So again, those are just some observations. This is not a topic I think we can address in one conference call, but I'm just trying to give you my thinking about it.
There is a very nice socio-economic study being performed by Stuart Redqueen, who investigated who benefit most from IP, and also looked at how what the impact is of price settings. So even if there is an exclusive position of someone in a certain IP or in a certain field, but the prices are that high that people are looking for alternatives.
Yes.
And so there's always a balance between the highly innovative aspect of the medication, and in this perspective, and the price. So if the price is too high, you will see that there will be reactions and people will look at alternatives. That's what I wanted to say.
We have a question here from Nikos Manaris. Could you please explain the role of regulatory data protection and why it is needed in parallel of IP and patent? So in other words, are they mutually exclusive? Are they competitive? Do we need them both? Who wants to take a crack at that?
Yeah, well, I can say I can say a bit of that. That's more in addition to IP rights. So regulatory data protection has more to do with third parties not being able or not being entitled to use data provided by others. That's basically it. Whereas IP is covering a whole field, or maybe the medication which yielded that data. So it is something else. So it could mean is that that when a medication is no longer under patent protection, you cannot use the data provided by others, which is under a data protection, but you can generate the data yourself.
Barbara, do you have another comment on that?
Well, just to add to that, if companies invest in developing the data, for an extension of the indication, for a new indication, for a different patient group, it's an investment. Generating these clinical studies it costs quite a lot of money. So making sure that others, that these data are then also protected for a certain period of time is really important to encourage companies to invest into, looking what other uses a medicine might have once it's discovered, and developing those uses. So again, you need a certain amount of time to recoup your investments in making sure that a medicine works for a new indication or in a specific patient group.
Yeah, and maybe to add to that, so I think data protection is not as absolute as patent rights, but in practice, of course, if you need to generate the data yourself, it will take a lot of time and a lot of investment.
But we have seen a certain lax approach by EMA in loosening access, and this has also been in collaboration with the industry. You can get access to that clinical trial data now through the data sharing requirements. So there are provisions there to start sharing those data. So they are being made available. I mean, do you see that as potentially hurting patent rights, or do you see that as I would think that it's both. I could see where the industry would have had issues with it, but it is happening now, and for the betterment of society, wouldn't that also be a boon?
Yeah, and you know what happens now, because of the transparency rules in Europe, these data need to be disclosed and once a drug is approved on the market, because that's part of European transparency rules. But who can benefit most from that? That is companies outside of Europe. So and that's of course what companies in Europe would like to prevent, is that Asian companies or maybe US companies are going to benefit from the data generated in Europe for their own good, for their own commercial interest. And so that means is what we will see in Europe is that large companies who develop an innovative medicine worldwide, they will not start first in Europe, but they will start first in another country.
Yeah. Yes. Yes, Barbara.
I think, if I don't misunderstand the question, I mean, data sharing and data transparency is something completely unrelated to regulatory data protection. I think today no company has issues with granting responsible access to the clinical trials they conducted, because they're certain of the data they have when they submit a marketing authorization. But that doesn't necessarily enable others, at least not in Europe, to make use of those data to get a marketing authorization themselves for a copycat drug. And we really need to differentiate for that. Companies are definitely all for giving responsible access to their clinical trial data, but on the other hand, that doesn't negate the need for regulatory data protection for the purpose of obtaining a marketing authorization.
We've got another question here. This would be again for Emil and Joep. This goes back to something you said, Emil, about your example in your WIPO example about going to countries saying that they don't have IP. Could VCs play a role in stimulating IP provisions in business contracts to increase the access to health technologies in low and middle income countries? Does actual venture capital provisions stimulating IP in contracts, would this be a voluntary process, or
Yeah, go ahead. Very interesting question, of course. So what that implies is that, look, let me take a step back. Typically, when we invest in companies, the IP protection focuses on the key areas, right, where commercialization typically takes place. And that again goes for a lot of other investors as well, because once you go into the national phase of patent protection, becomes very costly, right? So having said that, is there a role for the investor, and let me broaden it out to the investor community, to kind of, be more demanding as to where commercialization takes place, right? That's kind of the question that you're asking. Mm-hmm. And I think that's a very intriguing thought, because, and I may, have a slightly different view here than some others, but I do feel that the way commercialization happens today is not necessarily the same way it will happen 10 or 20 years down the road. Don't understand me wrong. I am quite convinced, like many, that IP is essential in this industry to protect what you're doing. And again, I don't think that will go away anytime soon. But to carefully consider where and which patient populations could benefit from your drug and be more demanding as an investor as to where these drugs get developed and where they get, where access is provided to patients. It's a very intriguing thought, really, because you could think of it purely from a commercial point of view and think, well, you're going to untap another source of income. You can purely financially. But you can also think of it in terms of if you bring an innovative drug into an area where there is little drugs available, you know that typically you're going to compare against standard of care. You know that typically you're going to combine it with other things. So you open up in another entire new venue into some areas that here too have had little access to medicine. So yeah, I find it a quite intriguing thought.
Yes, and Hilda Stevens sent us that question. Thank you, Hilda. Emil, from your position at World Patent WIPO, you're dealing with them. What do you think?
Yeah, well, it's a very complex issue. But first of all, I would like to say I would really encourage this kind of collaborations and providing and developing and least developed countries with these kind of innovation in innovative medication. But first of all, something needs to be done about the technology absorption capacity of these countries to really being able to at least have it produced there by themselves. And then there's the other thing is that there also needs to be some kind of IP protection in these countries as well to create some legal certainty, because no company would like to bring their innovative medicines to countries where there is no legal certainty, no IP structure, because they are very afraid that their medications that they end up via parallel import in Berlin for half of the price. And so you really need to do something about, like I said, about these two things. One is technology absorption capacity, and the other is create a legal certainty within these countries. And if you have these two in place, I think nothing stops a company from investing in such countries and bringing innovative medications to that country.
We've got a slightly technical question about biosimilars here, Barbara, which I'm going to throw to you. This is from Andrea Pucci. What do you think of the SPC manufacturing waiver? Question. Would it not be a good solution for the generic and biosimilar sectors and industries without tackling the IP protection? Deep breath, Barbara, yes.
Well, what it basically says, it allows other companies to manufacture a biosimilar before the additional patent protection that is only granted under certain conditions expires. You cannot sell it on your own market, but you can then sell it outside of the European market. I'm not sure that helps anyone, at least not in Europe. But on the other hand, it's also not my specialty to work on that. What I can do is I can go back and take this question offline with the person who asked it, and I would like to go that way.
That's fine. Thank you very much. We're running out of time here, and again, I'd like to thank the 100 people who registered for this webinar. One final question I'd like to put to the panel. Obviously, there's a lot of conversation, a lot of regulatory discussion. There's some controversy around IP right now. I think we can all agree, particularly in Europe, around that. Within the next 6 months, under the current EU Commission, I mean, this Commission is going to end here relatively soon, the next 18 months, what would you like to see done to help promote European IP, or at least address some of the issues that are being said? Barbara, I'll start with you. What regulatorily, or at least socially, would you like to see done around IP in Europe in the next 6 months under the current Commission?
It's a lot to ask for, maybe, but I think it's for the general public to begin to see patents as a friend rather than as a foe.
Emil, from your perspective, what would you like to see given the heat around this issue right now?
Yeah, I think first we really need to do something about IP abuse, alleged IP abuse. That is something that we need to tackle, I think, and there are some examples of that. And if we can find some measures to avoid that, that would be great. And I think we should pay a lot of attention to that. On the other hand, we also should emphasize more that IP is very, very important for IP-intensive industries, and you have seen in the presentation of Barbara is how important that is for the economic situation in Europe and the creation of new jobs. So I think there should be more emphasis on a clear relationship between IP-intensive industries and the creation of jobs.
Excellent. Yup, from your perspective, what would you like to see done regulatorily?
Yeah, I think another area that could be interesting is on the repositioning side. If you consider that some of the older drugs that have been off patent for a long time, typically in some smaller studies show quite a bit of clinical benefit. That's an interesting avenue. It's not actively exploited by pharma, but purely from a patient benefit point of view, it could really have a big impact, because these tend to be drugs that we know well, that we know how to manufacture, and are not very expensive. And I come back again to my point that even as an investor, I don't worry about that. It forces us to focus on real innovation, not on incremental stuff, not on something that gives an overall survival delta of 6 weeks or 8 weeks. It really forces us to focus on the real innovation, because that will have a place. But to maybe tap this, and maybe have some dedicated funding available for larger studies whereby you translate an initial early indication that an old drug could work in a new disease, and kind of, do that in a larger study, maybe in combination with a highly innovative agent. That's something I think where the EU could play a more active role.
It's fantastic. I'd like to thank the three of you for being with us today. I'd like to thank the audience for your participation. Again, our apologies for Henk Schues, who wasn't here. We will try to get him back for another webinar. Barbara, thank you very much. Emil, thank you. Joep, thank you very much. And with that, we conclude this webinar. Thank you, everyone. Goodbye.